Mr. Redding, yes.
My lords, my lady, earlier this morning, my Lord Hughes asked whether the practice of the New Zealand courts was that fresh evidence in such cases would be received bene esse, and my learned leader advised that we would make inquiries, and over the lunch, and I've been able to confer with a colleague who's in practice at the criminal bar in New Zealand, and he confirms that that is the case, and I'm able to provide 4 recent examples. I'm not sure if my learned friends take any objection to that.
I should probably have said something.
I'm grateful.
Yes, well, thank you very much indeed. That's very good of you. Yes,
my lord, my lady. If we could go, please, back to the appellant's case and go to paragraph 84, please, and deal briefly, if we may, to the issue of DNA. The evidence at trial was that DNA was taken from 2 stains. Those on the shirt. How it come about was a piece of the shirt was cut around the stain, and that was what was submitted for DNA. And I think the evidence was that it was washed, and it was from the washing that the DNA stain was taken. The respondents make the point that it is an astonishing coincidence, if this wasn't brain tissue, that the DNA of the deceased was found within this washing. We respectfully submit there are a number of fallacies within that submission. First of all, it involves an assumption that the DNA was found in the stain as opposed to the sample that was taken. The second...
Sorry, just explain that. What do you mean as opposed from the sample?
As opposed to proximate to the stain.
Well, I'd like to be quite clear about this. Presumably a piece of the shirt was cut out for further examination, and that would be a part of the shirt that had a stain on it?
Absolutely, absolutely. Yes. But the point, and we'll come to it, is that the finding of Mrs. Lundy's DNA on the shirt doesn't lend support to the submission that this is brain tissue.
Oh no, well that's a separate point, I see that. Yes.
But does the DNA come from the same part of the shirt as the alleged tissue?
Certainly proximate to.
Proximate to.
Yeah, and what.
But not integral to, not within the material.
It simply isn't clear.
You can't tell.
One can't tell.
Well, if it's from the washings, presumably you can't. But what will have been cut out, unless it's very unusual, will have been quite a small piece with the stain on it, and presumably a fraction or so round the stain.
Yes, one simply doesn't know.
So it's either in the stain or it's jolly close.
Absolutely.
Okay.
But the point is this: it only becomes an astonishing coincidence if one makes certain assumptions about the amount of DNA of wife's or daughter's DNA on the shirt. And of course, we can't make that assumption. So our simple point is...
was the rest of the shirt cross-checked for DNA? Presumably not.
No.
No.
But we do have... There was also DNA testing done on the specks which were found on the shirt, and that was found to be the child's DNA.
Yes, one of them was. That's right.
So I mean, what one can, in a sense, what's striking is that you have DNA testing of one area which finds the wife's DNA alone, and DNA testing of something else found on the shirt, and you get the child's DNA alone.
Yes. Yes, and as Professor Whitwell in her affidavit opined, this is absolutely, not only is it not uncommon, it is common to find the DNA of the DNA of other family members on other family members' clothing. Because, of course, the DNA can be from any sort of bodily tissue. And, of course, Professor Whitwell was not the only one who conceded that point. In fact, of course, we go back to Dr. Teo, who made that very point to Detective Sergeant Grantham. And of course, in the article we referred to earlier, next to the affidavit of Joe Jessup, written by Messrs. Temple Camp, Pang, Miller and Grantham, the point was made that the finding of the DNA in itself wasn't sufficient. So we simply make the point that it can't be said to be an astonishing coincidence. Because, of course, that would mean we would have to make an assumption about the quantity of DNA, whether it's daughter or mother.
Well, I thought that in the case of Amber, the DNA was found in what were specks of dried blood. Is that not right?
That's right, and that's absolutely correct. And there was one of 3 particles were examined, and that was right. But the same actually, well, first of all, insofar as blood's concerned, the evidence was that it was assumed to be blood. And it was assumed, the assumption was it was blood because they had applied a presumptive test called Castle-Meyer.
Well, it wasn't challenged then?
It certainly wasn't challenged, and that is part of our difficulty on appeal. But as any criminal practitioner doing murder cases after murder cases knows, presumptive tests like Castle-Meyer are full of false positives. Any root vegetable, potato or the like, will produce a false positive. So that, if you like, shows the limitations of the assumption that it was Amber's blood. Amber's blood.
What then can a jury make of this? I mean, is a jury entitled, in the light of what they had before it, to take it that this was DNA found in spots of blood? Were they entitled to do that?
Applying the burden of proof, one would say no, because there's no certainty that it was blood. There's certainty it came from Amber, whatever it might be.
Well, I think that the first question is the certainty that the DNA came from whatever the substance was that wasn't shirt? In other words, whatever the stain,
yes.
Whatever the stain was.
My lord's right.
It came from that, did it, the DNA?
We can't say.
You can't say that either?
We can't say.
So it's the same point as the wife's DNA,
yes.
either in or close to what either is or isn't brain.
So was it extracted by washing then, in the same way as in the case of the wife's DNA?
My lord, I would have to check that. I presume so, but I certainly would not like to mislead the court on that.
Well, they wouldn't have had to do make any slides out of that stain.
No,
I expect.
no, not at all.
They might have been able to treat it differently. I don't know.
Yes, I'm afraid I don't know, but I will find out overnight.
Yeah.
I'll look into that. Moving on from the DNA, if we can, at paragraph 86 of the appellant's case, Professor Gatter, Professor Whitwell and Dr. Squire all make the point that when they examined the ESR slides, they couldn't find and didn't find any blood cells. And they say that there was a conspicuous absence of blood cells, bearing in mind that the Crown's position was that this was brain tissue, and brain tissue from the body as a result of a traumatic injury. And three of them say one would expect to find red blood cells. They did not. And of course, the respondents make the point that Mr. Sullivan, at trial, the prosecution scientist, gave evidence that he saw blood. Unfortunately, he wasn't cross-examined to that issue at trial, and we're in the unhappy position of Professors Whitwell, Gatter and Dr. Squire simply don't see blood cells in the tissue. That is the point we make. Moving on, please, if I may, to our last heading under this ground of appeal, and that is, and hopefully I can take it shortly, that both Doctors Pang and Temple Camp relied on the report and evidence of Dr. Miller, and I'm now at paragraph 91 of the appellant's case. Dr. Temple Camp gave evidence that there was a high probability that this substance was brain tissue, but he had to rely on Dr. Miller's expertise to be sure beyond a doubt. And insofar as Dr. Pang was concerned, might I take the court, please, to volume 7, tab 34, and it's page 2639. Now, I suspect, my lady, my lords, that...
I'm afraid it's not very easy to read.
I'm hoping that a legible copy has come to you. Mine was totally illegible, and so we arranged legible copies to come to the court.
Yep. So it could be handed out. Yes, thank you.
Got mine somewhere.
Yes, it's this one.
We've got the score. I'm going to hand it through.
Oh, have we? Oh, today.
Sitting on the desk. Sorry, yes, it was buried in something else.
Thank you.
Yes, thank you very much.
Yes.
I'm not sure that I have it.
Did you get a thing like that? It was underneath that, which was the case.
Oh, yes, here it is. I'm sorry. Underneath that. Thank you. No.
My lady, I think it is in the bundle in your hand. I think I saw it.
Is it?
Well, I'm not sure we found it.
It is. Thank you.
Right.
This is a letter from Dr. Temple Camp, written after trial, 24th of November 2008, to a journalist in New Zealand. He's answering questions posed by the journalist about why it was that he, Dr. Temple Camp, had effectively changed his evidence or changed his position, to be put more accurately, on the state of the tissue. In a draft brief, a draft statement that he made prior to trial, he had said that the tissue was poorly preserved. By the 15th of February, after the trial had started, his final statement was served on the defence, wherein he described the same tissue as adequately preserved. And that is what the journalist was asking Dr. Temple Camp about. And he gives two reasons. Firstly, that he maintains that in one statement he was talking about one slide, and in the other statement he was talking about the Miller slide. We will see that, in fact, that cannot be so, because at the time he made his statement, Mr. Miller hadn't produced the slides or his report. But that is not the important part. The important part of this letter is the second page, and it's the middle paragraph, and he says, in considering the final statement, and that is the one where he describes as adequately preserved. In considering the final statement, it became evident that at that point, halfway through the trial, that the Miller tissue was so definitive that issues we had wrestled with in the early days with the ESR slide may have been interesting internally to us, but were irrelevant now to the court in the case. I realised that Miller tissue was the evidence to test, not the ESR slide. In fact, Temple Camp gave his revised evidence in reliance on Dr. Miller's, we say, flawed report. And that's the only point we wish to make in relation to that.
So where do we get out of this that Dr. Temple Camp has described the same cells as poorly preserved in one case and adequately preserved in another?
Certainly. Let me.
Do you agree that the first description of poorly preserved goes to was a description of the ESR slide made by Smear, and the other description of the tissue block made by Dr. Miller, or has he got that wrong too?
He's got that wrong, and I'll demonstrate it in a moment. If I could go, please, to...
But just before you do that, is it theoretically possible for a slide to be poorly preserved in ESR, but well preserved on the Dr. Miller slide? Is that theoretically possible?
It can't be. It can't possibly be.
Well, they're two different bits of substance, aren't they?
Well,
the first is taking off some by smearing, according to this letter anyway,
yes.
And the second is taking the whole thing, such as is left on the shirt, fixing it in a wax block and making the micron slices that are made for the purpose of the histology, aren't they?
Yes, but they come from the same stained substance. And unless one's suggesting that by wetting the slide and wiping it across the stain, you might collect only degenerative tissue, but when we look at the other, which we suggest is a nonsense because it's from the same stain, it must be the same.
So
he's looking in essence at the same thing.
So that's the hypothesis.
Yes.
Is that your proposition, or is it a scientific proposition offered by one of the experts?
Sorry. Yeah. I think, in fact, Professor Whitwell can assist us with that.
On the basis that there's a uniform rate of degeneration, of degradation, is that the basis on which you make the assertion? It doesn't degrade or degenerate at different levels.
Well, I see the point in no, our explains nobody addresses the it's not the rate of degeneration, it's the position of degeneration. Whether it degenerates from inside out or outside in, we don't know.
Your proposition is that there simply has to be the same level of degeneration.
Well, one would reasonably think so.
Right.
But the point is that Doctors Pang and Temple Camp relied, we say, on the flawed results of Miller's tests, and that indeed had an effect on the nature of the evidence that they gave at trial.
Well, you mentioned that Professor Whitwell has something to say about the comparison you've just been talking about. Is that the only? That's the
might I
substantiation you have for the submission, is it?
Yes. Can I take you please to volume 6, tab 31, please.
Did you say 31?
Yes, my lord, yes. At paragraph 6 to 16, she addresses the changed position of Dr. Temple-Camp, and it's within the exhibits to her affidavit that we find, and the references to, and it's at 2521 is the first one, is the Temple-Camp change in position.
Where does she deal with his answer, such as it is, that he's describing two different objects?
Right. At 7A, she addresses the and says this about 3 lines down. Dr. Temple-Camp describes the cellular material as poorly preserved. If poorly preserved as observed on the 5th of January 2001, and that's what he does say in his statement, the tissue could not have been well fixed, as otherwise there would have been no breakdown of cells, as he quite obviously observed. I cannot understand this change of position by Dr. Temple-Camp, and it causes me to wonder whether he is really sure what he could and could not see.
Well, yes, but for what is right or wrong, what he says is it's two different things. Where does she deal with that?
There's paragraph 15.
Yes.
The statement
This is
quite strong on it.
Yes. I won't read it all. However, his explanation is wholly unconvincing. Dr. Temple-Camp seeks to justify his changes of mind on the state of the tissue by saying the ESR slide was the poorly preserved one, and the Miller slides were those that showed a remarkable degree of preservation. This, I am afraid, is an impossible explanation and completely nonsensical. The statement of Dr. Temple-Camp makes abundantly clear that the slide he was considering was that given to him on the 5th of January 2001 by Detective Grantham. This was the ESR slide. At this time, the Miller slides did not exist. And it goes on.
And then she makes the same point that you do.
Yes.
Yeah.
Yes.
Yes.
And if I may, just backtracking, please, to paragraph 7, but 7 goes over the page at 2508, and the last sentence of paragraph 7. The answer to this cannot be that he was looking at different slides. The tissue is all from the same stain on the shirt. And looking at 2521, please. This is the statement of Dr. Temple Camp that we refer, and to make the point that he was indeed talking about the same tissue. He's bottom of the page 2520. On the 5th of January 2001, Detective Sergeant Ross Grantham asked me to examine a slide containing cellular material which had been lifted from a shirt. We know, of course, that is what's known as the ESR slide, and the Miller one didn't exist at that time. And he goes on, I examined the slide under a microscope, found components of tissue including blood vessels and cellular material which was poorly preserved but appeared to me to be brain tissue. And then if we go over the page to 252, we have his second revised statement, and indeed this is the evidence he gave at trial on the 5th of January.
Which page? I beg your pardon.
So 2525.
25. Yes.
His subsequent statement, and that which mirrors his evidence at trial, on the 5th of January 2001, Detective Grantham asked me to examine a slide, and he goes on, we know it's the ESR slide, and also we know Miller's one doesn't exist, and this time over the page I examined the slide under the microscope, etc., and the cellular material which was adequately preserved.
So it's the word adequately. The word adequately, which is the change.
Yes, adequately preserved, that's right. And the point we make is he explains why he changed that in the letter, and it was because of Miller's evidence.
But what is it we're looking at? Is this a document? Is this a statement taken by police officers? Or?
Yes.
Right.
Yes. These are the statements that are taken prior to trial and served on the defence before trial, as in essence advanced information about the evidence that the prosecution intend to lead. Both of these were served on the defence at different times, insofar as this is concerned.
So the relevant paragraphs are word for word identical, except for the word adequately and poorly. And then a little further on, the paragraph which is on page 2521, which begins the preservation on the slides of the cells on the slide was suboptimal and I was concerned, has disappeared.
Yes. Yes. And so it causes one concern when one looks at the attempted justification of it in the letter.
Is it the case that both statements were made before Dr. Miller's slides came into existence?
No. The latter one, 15th of February, Miller's report had already been come into existence and had already been served and was in the hands of the police.
But the paragraph that my Lord has pointed out varies in relation to one word only, that related to the examination of the ESR slides.
Yes, yes, my Lord, yes.
So your point is that the ESR slides were either poorly preserved or they weren't, and nothing about Dr. Miller's subsequent examination, whether or not we get involved in this debate as to whether different parts of the same sample can have degenerated at different rates. Your point is that this is a change which cannot be explicable by reference to Dr. Miller's report.
My Lord. No, but that is the explanation that he gave for the change. Looking at Helen Whitwell's affidavit still, while we have it open on this point, paragraph 12, She makes the point, this is not the only change of mind by Dr.
Sorry,
Paragraph 12, my lord, 2508 at the bottom. This is not the only change of mind by Dr. Temple Camp. At a time prior to trial, when the issue of how the tissue became lodged onto the shirt was not the central issue, Dr. Temple Camp made the original draft statement referred to above, wherein he described the rapidity of degradation of tissue once expelled from the body in the following terms, and this, in fact, may assist us. Air drying is a good method of preserving cells, but the preservation has to be carefully and expertly done. Some experts maintain that this requires the presence of cystology laboratory staff at the procedure when the tissue is removed from the body. The damage that occurs to incorrectly prepared tissue takes a surprisingly short period of time, reported by some experts to be 10 to 15 seconds. If material is not rapidly dried, then cell breakdown occurs and there is a rapid loss of detail which can make the interpretation impossible. Experts report that the loss of cell structures and the antigens that identify them occurs very rapidly over a period of from seconds to minutes, depending on the amount of blood or mucus surrounding the tissue. Paragraph 13, however, in his 15 September 2002 statement, Dr. Temple Camp added a paragraph to the end of the statement expanding the optimal time of air drying from seconds to minutes to a few minutes to a few hours after expulsion from the body.
Does he do that? Do we find that on page 250?
So that's 2509, my lord, and that is part of the affidavit, paragraph 12.
Yes, quite, but I'm just trying to see where it is in Dr. Temple Camp's letter.
Oh, I'm sorry. Yes. This is what's being, referred to.
Well, it's the change that's been referred to in this paragraph in timing.
We can pick up that at page 2522, air drying is a good method. That's in the draft.
Yeah.
And then looking over to the final. 2527.
2527.
Yes. Air drying is a good method. Goes on.
So 10 to 15 seconds in the draft. Still 10 to 15 seconds here.
Right at the end of 2529.
Yes. Yes. Experts report. My lord, thank you. That is the passage.
Yes. Right. So that's the bit that's added in.
Yes.
Yes, it's a sentence, the time of air drying, the last two sentences are new. Yes, I follow. Thank you.
Dr. Whitwell makes those points.
Can you just assist me? I'm now slightly confused about the timing of this disclosure. When was this disclosed, the draft report and subsequent one?
The draft was, in fact, disclosed to the defence prior to trial.
Yes.
Yes. Sorry. During the trial.
The memorandum is in the...
Sorry. I'm being corrected to my left.
That's all right. Perhaps you can return to it. I just wanted, while I was thinking about it, to know it.
Right. Thank you. If we could go perhaps to the appellant's bundle, and it's tab 4. Oops.
Is this a supplementary bundle?
This is the appellant's bundle, and this is tab 4. Tab 4, my lord, is at, we see the first page in that is page 78 at the bottom, and we're looking at page 82.
It is a supplement.
Yes, sorry, supplement. This is a memorandum by trial Crown Counsel, prosecuting, and it explains to the court that the late notice of calling Dr. Templecamp at trial because by then, that's the 13th of February, by then it had become apparent that there had been a concession about the identity of the tissue, and the only live issue in the case in relation to the tissue was how it got on the shirt and dried.
Can I make a rather prosaic inquiry? Was this a concession made that this item of evidence was not going to be challenged, or was there an agreed fact between prosecuting and defence counsel to be put before the jury?
On the brain tissue?
Yeah.
There was certainly no memorandum, but it's difficult to know when the concession made, but the concession was indeed made because when...
Well, we're not in any doubt as to whether the concession was made, and this is, as I emphasise, a very prosaic inquiry, but did Dr. Miller need to give evidence in order to establish it, notwithstanding the fact that he wasn't going to be challenged? Or was it a question of the parties agreeing that the jury could be told?
Yeah. There was no admissions of fact. No admissions of fact.
So he had to give evidence in order to establish that.
But it's right to say that during the course of cross-examination of Dr. Miller, trial counsel referred to the tissue as brain.
Yeah.
And so, so that memorandum hopefully sets out how it was that Dr. Templecamp come to give the evidence.
And so is the answer to the question that the distinction between the draft and the later witness statement, they were both there for the defence team at the trial?
Yes, yes.
But I suppose the fact that they decided to concede that it was brain tissue rather overtook the significance that might otherwise have been attached to the discrepancy.
Well, not necessarily, because of course the central issue in the trial was the state of or how the deposit occurred, and if it was wet and had self-preserved, as was the prosecution case, there would be no degeneration. But if dry, then of course there would be degeneration.
Well, the principal defence was, principal may be overstating it, but a large plank of the defence was plant, wasn't it?
Yes. There was either...
It wasn't some mistake. Well, it was plant.
Accident or plant.
Yes.
Well, yeah.
But the emphasis on plant.
Yes. Yes, that's right. Moving on, please, if we could now move to the ground 2, and that is we address at paragraph 29 Sorry? No.
I'm sorry, can you give me that reference again?
Yes. Yes, 94 of the appellant's
It's your case, paragraph 94 we're looking at now, isn't it?
Yes, thank you. We set out in a paragraph there the law we respectfully submit as applicable in New Zealand. and refer, of course, to the New Zealand Bill of Rights, and we respectfully submit that the disclosure is part and an inseparable part of the fair trial guarantee under Section 24D and Section 25A of the New Zealand Bill of Rights. We refer therein to the English authorities of Alibi and Ward, to which we have already referred, and we set out at 26 the case of McGuinness. We refer to McGuinness, and we recite there the principles we say apply in that regard. And so far as non-disclosure is concerned, we, with respect, say that we have absolutely no confidence whatsoever that the officer in charge of this case met his disclosure obligations. And there can be no greater example of that than the TO memorandum to which we replied earlier. If I can address that more fully, and turn up, please, the affidavit of Mr. Grantham, and we'll find that, please. It is in volume 5. At tab 18, please. I'm sorry, 18.
Thank you.
Paragraph 6, he sets out that he was officer in charge of, among other things, the disclosure. He maintains at paragraph 10, I never conducted an expert shopping exercise. Pausing there for a moment, the respondents in their response suggest that expert shopping is where the police identify someone who gives them an opinion about a certain result, and they discard it and go on to look for a different result.
Well, is it not the idea that they know the result they want to get, and they're looking for someone who will give them that result?
Yes.
If the first person doesn't give it, they look somewhere else to see if they can get it from somebody else. That's a suggestion. Yes,
my Lord, that's right. And we say that the document to which we referred, the Teo memorandum this morning, is evidence exactly that.
Well, I understand the tier point. The tier point is failing to disclose. It's not so much shopping around. It's failing to disclose that Dr. Teo had offered an inconvenient view, and that should have been disclosed. You say?
Yes.
Yes. But otherwise, the complaint is it that they went looking for, didn't say, we've been looking around the world for various laboratories and Mr. Miller is the only one we can find.
That's right.
Is that it?
That's right. And
is there any reason why they shouldn't go looking?
Pardon?
Is there any reason why they shouldn't go looking?
There's no reason at all, as long as that's disclosed to the defence. Because, and I'll get to it in a moment, but just on the Teo point and disclosure, And what was evident from that disclosure was that inquiries were made of an Australian laboratory. Well, immediately we received that memorandum last week. We put in a request for disclosure in relation to that laboratory. Well, we're still waiting. It hasn't been disclosed. So we don't know what that laboratory found.
I'm sorry, do you know that the laboratory did provide a report?
What, that particular one?
Yes.
We've got,
you don't know. All you know is that the request was made of the laboratory.
Yes, and we don't know the response.
Don't know if they made any response.
No.
Well, it looks from the bit that you've quoted in your paragraph 100 in your skeleton or your case.
Yes.
That you're relying on what you've got from Dr. Miller's subsequent newsletter, viz. They'd asked lots of people whether this was a test that could be done, and had got the answer until they got to Miller. It was a test that couldn't be done.
That's right.
It wasn't that it didn't produce the result. It wasn't that it had produced the wrong result. It was that nobody else thought it could be done. So it's the novelty point again, isn't it?
Yes.
Yeah.
Yes. Yes, absolutely.
Which, as you've already explained, they knew perfectly well by the time of the trial.
Yes.
It was novel.
Yes.
Well, in '99, you say Dr. Grantham contacted several well-known forensic laboratories worldwide. Well, do you have disclosure in relation to the contact with the...
Two of them, and I'll get to them because they're important.
Oh.
Yes. Just whilst we've still got D.S. Grantham's affidavit open, if we may please, we can see how he treated the Teo disclosure. He finds at 16, in January 2001, I showed the slide C30032 to the following local pathologists: Dr. Ken Thompson, who gave it to his histologist, Dr. Peter Bethwaite, Dr. Heng Teo, Dr. Sinric Temple Camp, and Dr. James Pang. None of them was able to conclusively identify the material. Well, in fact, according to the memorandum, Teo said brain tissue could not be identified because the tissue had degenerated so much. So insofar as that statement by the officer is concerned, it was wholly misleading. Going on, if we may, to paragraph 101 of the case. A disclosure request was made to the Crown in November 2012, and there was a response on the 21st of February. One of the requests was for correspondence or communication of any kind with experts or potential experts concerning the analysis of tissue on the applicant's shirts. The Crown's response sets out D.S. Grantham's affidavit responds to your disclosure request by identifying all the discussions that the Detective Sergeant Grantham had with various experts and explaining that the defence were aware of these discussions at the time of trial. The actual correspondence was not disclosed to the defence, nor was it requested. No disclosure obligation was engaged because the correspondence could not have been used to assist the defence. We pause there. Nothing could be more untrue insofar as the Teo disclosure is concerned for a start, but it goes further than that. Despite that fact, there was and is no disclosure obligation. I have attached a copy of the correspondence of Dr. Rodriguez and Dr. Doyle as Annexure B. I have done so purely to show you that the allegation of expert shopping is completely unfounded. Well, we say the disclosure, which we'll move to in a moment, is problematic. D.S. Granthon's affidavit does not explain in his affidavit that none of the personnel at these offices thought that the staining would be successful, and it's to that which we move to now. Over the page at 105, Dr. Rodriguez was a pathologist with the United States Armed Forces Institute, and we set out there the correspondence that was disclosed to us.
Sorry, now where do we find that? You said 105?
Yeah, 105, that's our 105 of the
You quote from his...
Oh, I beg your pardon, in the paragraph, yes.
Yes.
You're quoting from his paragraph.
Thank you.
Yes.
Yes.
And the passage to which we refer is towards the end of the first paragraph. It is highly doubtful that the shirt stains contains enough material for the specific examination. Secondly, primer studies and analysis conducted by our institute, which is strictly research in nature, have dealt with organ material other than neuro tissue. Sorry.
Is it perhaps the clause beginning with capital letter B that's most relevant? That's dealing with the technique used by Dr. Miller.
The paraffin fabric followed by slicing.
Yeah.
Yes, that is addressed.
Well, you're saying they've tried it and haven't succeeded.
Yes, and going on from there.
I'm just trying to think where the disclosure gets you, Mr. Hislop. If this had been disclosed, what could the defence have done with it? Call Dr. Rodriguez, I suppose.
They could have done
to
that.
Say, I'm surprised it can be done, but...
Well, I think that what you could have said was, this casts doubt on the viability of your examination techniques and the results that they claim they yield. Yes. Because here is a highly reputable laboratory which says, as a matter of generality, that this is something that is extraordinarily difficult, if not impossible.
Yes, but you'd have had to call Dr. Rodriguez to do it, wouldn't you? You can't just put in the letter.
No.
Well, you might have cross-examined Dr. Miller.
If the disclosure obligation was met in the usual and expected way, then of course one would go to Dr. Rodriguez.
Yes.
Yes. Incidentally, just further up the page, in fact, what Dr. Rodriguez says is the suggested procedures you listed are not feasible for several reasons, and he lists those. He then goes on towards the end of that paragraph. The problem for staining is that it will also require significant cellular material in good condition. And again, these are indications for trial counsel to prepare his case in a proper way, to meet...
And not to make the concession.
Oh, yes, that's the point.
Yes, not to make a concession.
Yeah.
To what extent, though, is this a distinct ground, and to what extent does it feed into your first ground?
First of all, it's a standalone ground. And
I know you're putting it like that.
But it feeds into ground one when we're considering, for instance, that's the freshness argument and the argument, something's gone wrong here. Something's gone wrong. So that's the interrelationship. Interestingly, we have that piece of disclosure from Dr. Rodriguez, and we see, of course, how D.S. Grantham seeks to deal with it in his affidavit. And my learned junior makes the very good point that, of course, D.S. Grantham made his affidavit prior to this disclosure being made by the Crown. Sorry. Yes, yes. And the point being that he did make his affidavit in the way that he did, and we set out that part of his affidavit at paragraph 106 in the safety, that at the time that he made that affidavit, of course, there was no prospect of disclosure unless leave was granted. And as to Dr. Rodriguez, he says at the very end of the passage that we've lifted from his affidavit, he did not suggest to me that paraffin embedding could not be done, or that the material on Mr. Lundy's shirt could not be identified. Well, in fact, he in fact says that it was not feasible for several reasons. So again, D.S. Grantham's affidavit causes us concerns. It would seem in our respectful submission that D.S. Grantham's description of this exchange is selective, incomplete and entirely misleading.
What do you mean by the second sentence in paragraph 107? These potentially relevant documents. What are those?
So this is how our disclosure request the Crown.
Yes.
Got him to go and look over things again to make sure there's nothing they've missed.
Yes. I think it's a reference that D.S. Grantham oversaw the exercise by which potentially relevant documents were supplied to the Crown Law Office so they could certify that the Crown's disclosure obligations had been met ahead of the appeal. That was, he was tasked to do that for the respondents.
The way I read that was he was really the cipher. He was the filter through which the documents were coming to the Crown Office. He's what would be described, I think, in this jurisdiction as the disclosure officer.
Yes.
And really the Crown agents are relying on him to produce the material that they can verify is all of the relevant unused material.
Yes, my lord, that's right.
Is there a requirement, or was there a requirement at this time, for the preparation of a written disclosure schedule?
My lord, I can't answer.
By the officer in the case, or by somebody?
I certainly, I'd have to defer to my learned junior for that.
He will defer to his contacts.
I'm afraid I don't know the answer to that.
We'll find out overnight. We'll find out overnight.
I mean, the duty is the same, whatever the procedure may be adopted to perform it. But,
yes, quite.
In this jurisdiction, as my lord says, there'd be a disclosure officer charged of making a sometimes inordinately long list.
Yes, of signed off unused material schedule.
Yeah.
We, at paragraph 111, make the point the potential importance of these suggestions was not lost on D.S. Grantham, who replied by fax to Dr. Doyle, and this has been disclosed. Dr. Rodriguez, 19th of April 2001. Oh, I am sorry. What I've done is I've skipped a paragraph, and perhaps I could go back because that will make no sense at all. Paragraph 108, I'm sorry, D.S. Grantham also corresponded with a Dr. Doyle, a neuropathologist at the Institute of Neurological Science at the Southern General Hospital NHS Trust. The correspondence, in fact, is a little surprising because in the respondent's notice of objection to our application for leave, Crown Counsel made no mention of it, instead advising that DS Grantham had confirmed to him that the Home Office from which he sought assistance did not reply. We don't blame Crown Counsel for that. Paragraph 109, we address the further disclosure. The subject of this previously undisclosed correspondence was Dr. Miller's report. DS Grantham's affidavit of the 30th of January 2011 describes the correspondence in this way. After receiving Dr. Miller's report, I received a response from Dr. Doyle, a pathologist in Glasgow, who I had tried to contact. I sent to him a copy of Dr. Miller's report to review. He agreed with Dr. Miller's conclusions, but suggested that further controls could have been used. In response, I explained the multi-tumour sandwich block controls that Dr. Miller had used. Dr. Doyle was satisfied with that response. With respect, this is not a complete description of the correspondence. Dr. Doyle's previously undisclosed letter of the 12th of April 2001 contained the following statements, the relevance of which ought to have been clear at the time, and the significance of which we say is now clear in the light of Professor Gatter and Sherd's evidence. And we include that part of that undisclosed material hitherto there. And Dr. Doyle says this, where I would have added to the work would have been in ensuring that the dimensions of recognisable structures, e.g. nerve cells, cell nuclei and nuclei, and cell processes of whatever type. I should also have set up control material such as other human brain in similar amounts on similar fabric. It would be unlikely that the results would conflict with those already obtained. I think if I were a defender, I would like to know that the same results could have been achieved in different laboratories. Again, I do not expect that there would be any conflict in the results of the repeat studies done in a second laboratory. But when a novel approach is taken, corroboration may be thought desirable.
Can you help me as to where we find this in our bundles?
Oh, yes, that is in volume 7, please.
Thank you.
Tab 44.
Thank you very much.
Rodriguez.
2751, I'm told.
Sorry, say it again, please.
2751, my lord.
2751.
Yeah.
We see the top of the page, the fax correspondence, 12th of April 2001. I think if I were a defender, I would like to know. And of course, backtracking on the 2750, talking about adequate, and this is about 7-8 lines up from the bottom of the page, adequacy of control material and negative controls is essential for interpretation.
He goes on to say he doesn't have any difficulty accepting the interpretation made in the USA.
Yes, yes. Of course, Dr. Doyle, of course, was not, didn't have the advantage of seeing the tissues.
He does offer to undertake a similar assessment, presumably not taken up. And he does also make the point that although the DNA match is important, some further confirmation of the nature of the material is desirable.
Yes, my lady, thank you. Yes, that's right. And at 2747.
He does also say, well, he says that he would have added to the work by way of carrying out various controls. He says it would be unlikely that results would conflict with those already obtained.
Yes. Of course, what Dr. Doyle wasn't told was the what we now know Dr. Teo said about the degenerative nature of the tissues and why it was that is unfixed for 59 days.
But forgive me, all that they're doing is trying to find somebody to do the immunochemical histology test. And they've got Dr. Doyle who would be willing to do it. They don't take him up on it. If you disclose that, which you might or might not, I'm not at all sure that you would. If you disclose that, what are the defence to do with it? Nothing. They're not under an obligation to tell Dr. Doyle their whole case, are they?
No, they're not. But if one's seeking to rely on the statement, I have no difficulty accepting the interpretation made in the USA,
They're not.
One's got to ask what they knew, what Dr. Doyle knew. But the short point is this. Here was a piece of disclosure. It could have, in the hands of trial counsel, assisted him in his defence.
How?
Because he would have been informed, as sadly no other expert informed him, that a jolly good idea might be to go off to another laboratory, not just have someone read Dr. Miller's report, but go off and try and replicate the results.
Well, come on, Mr. Hislop. You can say that of every scientific experiment, and indeed, I was going to ask at some stage why it hasn't been done now. Mr. Miller says the stuff's still sitting there waiting in his laboratory to be tested again. Has anybody asked to do it?
Well, what Professor Gatter and Dr. Wayne Squire say, 23rd of April of this year, 25th of April of this year, we looked at these cells. They are in such a degenerative state that it can't be done.
Yes, that's
the answer. That's the answer.
That's the answer.
It can't be done for reasons we addressed this morning.
Well, he seemed to, looking at page 2750, at that stage, the copy photograph suggested it was more tissue material than he imagined. No need for amplification techniques. Was he working under a misapprehension at that stage? And he seems to be thinking that there was enough there to carry out the necessary examination.
Yes. To be fair, I think he's simply working on Dr. Miller's report, or a report of Dr. Miller's report. I presume, commenting as he has had Dr. Miller's report. Because, of course, he's in a position to comment on the methodology and makes the suggestions that he does. So the going back, that communication having been received by Dr. Doyle, going back in our bundle to 2747, D.S. Grantham, at the middle of that page, replies, your point of a second opinion on evidence obtained by such a novel approach is most relevant and is the main topic being considered by our Crown Prosecutor. It can't have been lost on D.S. Grantham or the trial prosecutor the importance of what Dr. Doyle was saying, and our points are that, and we summarise them at paragraph 113 of our case. The correspondence with the two doctors was clearly relevant. Rodriguez declined to conduct testing because of his concerns with the nature of the material available in the proposed testing process. Dr. Doyle indicated that there were matters that the defence ought to investigate relating to controls used on what was a novel experiment. And in particular, they ought to investigate whether Dr. Miller's experimental results could be replicated in another laboratory. Now, these are the same matters which Professors Gatter, Sherd, and now agree are fundamental and which they say undermine Dr. Miller's report. And Professor Sherd has recently reviewed the disclosed material and confirms its materiality. And 14, sorry. Moving on.
Sorry, what was that point? Professor Sherd has confirmed the materiality.
Yes, yes, the materiality of the disclosure made by the Crown just recently. And if we can go to Sherd's second affidavit, please. And we find that at volume 6, and it is at 26.
Volume 6 at tab
26.
26.
2365.
No, it's not, I've got the wrong volume, it's volume 6.
2639.
Sorry, 2635. Yeah.
Is this the affidavit that the respondents say would have been better coming from council as submission?
Yes. Regardless of who makes the points, we respectfully submit the points are well made. And there, Dr. Sherd addresses the recently disclosed correspondence at paragraph 19. In paragraph 20, he says in relation to Dr. Doyle's letter, he states, adequacy of control material and negative controls is essential for interpretation. He says, I couldn't agree more. And this is central to my concerns about Dr. Miller's methodology and evidence. Then he addresses the if I was a defender disclosure, and further down he says, however, this is categorically not routine histopathology. This is an uncontrolled experiment. As a matter of standard scientific methodology, no single experimental outcome in isolation is ever accepted as providing the definitive answer to the motivating question. It is normal and expected that an experiment will be repeated, usually at least 4 times, before any reasonable interpretation of the result can be made. Second, it is normal for the important outcomes to be repeated and independently corroborated or refuted by other investigators. In essence, Professor Sherd and Dr. Doyle were essentially in agreement. The point again, disclosure of Dr. Doyle's communications might have informed trial counsel and his experts in relation to that.
Well, he's saying in this that not only is it necessary to have a control, but the investigations have to be carried out in separate laboratories. Is that what
Well,
you're saying?
that's what Dr. Doyle maintained.
No, I don't think Dr. Doyle maintained that. What he said was, if I were a defender, I would like to know that the same results were achieved in different laboratories. And that's a far cry from saying that in order to produce valid test results, it must be carried out in separate laboratories. Now, is Professor Shad espousing the case, and is it the appellant's case on this appeal, that for these test results to be valid, not only did you need a control, not only did you need fresh material, or at least non-degraded material, but also that you had to have investigations in separate laboratories?
That's not our case.
Well, he's saying that, I think.
Yes,
what he understands by corroboration. You have to
Yes.
have an independent check. And the best way of achieving it is to have a separate laboratory. But that's putting it very high, and you're not insisting on
It is. An independent check is an independent check, whether that means in the laboratory or not. These are presumably professional people.
Well, while you're on repeatability, Mr. Hislop, you told us just now that there couldn't now be a repeat because Doctors Gatter and Square, and perhaps Shared, advised that the slides were incapable of it.
Yes.
Can you just, at some stage, tell us where we find that? Because I've just been looking at the Gatter Squire report, and I must be missing it.
Yes.
2359 is where their up-to-date report is.
Yes. If we go...
First of all, before that's Shed's report. Shed deals with the point where I've got it open.
Yes. Right. I'll put this open.
Yeah.
Yes. I'm sorry. Yes. It is volume 6. And this is paragraph 22.
Tab 22.
Sorry, tab 26.
26.
26, not 25, beg your pardon.
26.
Oh, that's Shared.
Yes. Yeah.
That's Shared. You
This
said
is Shared dealing with the same point.
Right. Well, all right, let's go there first.
Can I have it?
This is repeatability
Yes,
we're on.
here is the same point. I do not agree with Dr. Doyle, however, that this corroboration could be achieved using Dr. Miller's paraffin blocks. This is because the concern is not whether Dr. Miller's lab processed the blocks properly, but how the tissue was handled and processed before it was embedded in paraffin. What makes the experiment uninterpretable relates not to how Dr. Miller processed the tissue after it arrived in his lab, but the fact that it arrived in Dr. Miller's lab as air-dried, unfixed, degenerated material for which no proper control was included.
I'm sorry, that's Shared to...
That is Shared, and that is 2365 at the bottom, my lord.
2365, thank you very much. 22, got it.
Yes. Again, this is slightly misleading because it implies that a proper control could have been included, but as I understand your case now, that isn't the position.
Well, it's if it could be. The difficulty is to replicate unknown conditions that applied to the substance on the shirt.
But Dr. Shared's starting proposition was, the trouble is we don't know that the antibodies are specific. You've got to have a control sample of fresh brain.
Yes.
Not presumably necessarily Mrs. Lundy's brain, but somebody's, in order to do the test. But you still could, couldn't you?
No, you couldn't.
Why not?
Because that's one side of the equation. On the other side of the equation is we don't know what the specificity is for the antibody on a substance, say brain, that has undergone the same conditions as that on the shirt. So we can't ever compare like with like.
In other words, to have a control, you'd have to have something that is undeniably brain tissue or spinal tissue.
Yes.
You then have to put it through a process of degeneration which mimicked the process of degeneration that this tissue, if it is brain tissue, must have undergone.
Yes.
And because it's impossible to replicate all the imponderables that go into that particular exercise, then it's impossible to have a control. Well,
Yes.
The only point that I'm making, again, is a very banal point. It's a pity Professor Sher didn't say that, instead of implying, as he seems to me to have done, that it might have been possible to have a control. I mean, if the situation is as stark as it now appears to be, that no control was ever going to be possible here, it might have been happier to see that explicitly stated.
Well, I wonder if I could take the court, please, to Sherd's first affidavit, please, and that might assist us. And we find that at volume 5, and it is tab 12.
Sorry, I beg your pardon.
I'm terribly sorry.
Yes, it's fine.
We can find that answer to that in Dr. Sherd's first affidavit, and we find that at volume 5, please. No, I'll use mine. Oh, that's mine. Volume 5, and it is at tab 12.
Yes.
And if I can take the court, please, right through to his report, and the report we find, it starts at 1924. And if I can go to the discussion and conclusions, 1942, please.
Well, there's something at 1927 about controls.
And 25.
Suggesting one might be able to get a satisfactory positive control, but without it, of course, you don't. You have no way of knowing whether the results are going to be reliable.
Yes.
But you're saying we go on to a later passage,
Yes,
a page?
if we can. 1942.
Yeah,
And 3 lines up.
right.
Significantly, no antibody will have been tested on tissue left unfixed and exposed to air for several months prior to processing. Such a major deviation from normal processing protocols renders antibody reliability unknowable and therefore mandates prior experimental testing and establishment of conditions under which the antibody can be shown specific and reliable if such conditions exist. For this reason, I consider the processing of the material on the Lundy shirt to be an uncontrolled experiment without reliable outcome.
Well, that still leaves open the point.
I'm not sure that we need to spend much more time on this. I mean, it was just probably a fairly petulant observation on my part.
But I thought
do move on.
I thought Professor Whitwell was, when we looked at her stuff earlier on, was saying it couldn't be done. But I may have misinterpreted her too.
I think the couldn't be done as a product of the unknown conditions.
Yes, you're saying that he is saying that it can't be done
Yes.
in this.
Yes,
Yes.
Absolutely.
It's
And
a computery way to say it.
Well, he's a son.
yes, yeah. My learned junior makes the point, if we knew the conditions, we could do it.
Yes, quite. Right. Well, perhaps we should move on a little more rapidly because time is running on.
Yes, absolutely, if we may. The points we make that material could have obviously informed the lines of inquiry with the trial counsel's own experts, possible defences, cross-examination of Crown experts, trial strategy and decision-making. The further non-disclosure we would like to refer to, please, is that at paragraphs, we refer to paragraph 121, and this is the disclosure relating to Mr. K.J. Thompson. He's the pathology advisor to the New Zealand Police. It's dated the 14th of December 2000, wherein D.S. Grantham was advised that it was impossible to confirm whether the scanty material on the slide was of nervous system origin by microscopic analysis, and that specific tests were required. It was he who advised the contact with Dr. Rodriguez. For the reasons provided in the affidavits of Professors Sherd and Gatter, it seems clear that such a person didn't exist because, of course, of their observations about the possibility of IHC being used when you have an unknown substance that is sat round in unknown conditions. The letter, Mr. Thompson's letter, indicates, we say, the fragility of the evidence at trial regarding the identification of the substance on the appellant's shirt as brain tissue. The letter, this is at 124, contains the following statement: the slide has scanty material present, and while there are some cells which are possibly of nervous system origin, it's impossible to confirm this without specific tests. We obviously contrast that statement by Mr. Thompson with the subsequent certainties of Dr. Templecamp and Dr. Pank. The respondents' reply to us in relation to the non-disclosure of that particular letter is that they suggest that they simply don't know whether it was disclosed or not. We say certainly it's inconceivable that it was disclosed, otherwise we might have seen some cross-examination, at least on the subject matter, or an attempt to call Mr. Thompson himself, because of course this was a live issue in the trial. Certainly, moving on, if we may, and perhaps back to the Queen and Ward, and we have that at the authorities bundle, and might I just refer to Ward before we move on?
It's volume 3, tab 40. Volume 3, tab 40.
Volume 3, tab 40.
Is this the authorities?
Yes, the authorities bundle, thanks. And we say this in relation to, in particular, Dr. Teo, and just looking at the case of Ward and the first page, from the head note, the prosecution were obliged to make available to the defence any witness whom they did not propose to call, but whom they knew could give material evidence which tended either to weaken the prosecution case or strengthen the defence case. And they had a positive duty independent of duties imposed by the Crown Court Advanced Notice of Expert Evidence rules. We say Dr. Teo ought to have been disclosed to the defence. It materially would have materially affected a very live issue in the case as to whether or not this tissue was degenerate or not.
I think you might prefer to rely on the later, just succeeding passage, that the duty was to disclose any scientific evidence which might arguably assist the defence. Now, that is apparently consequent on duties imposed by the Crown Court Advance Notice of Expert rules.
Yes.
Expert evidence rules. Is there any equivalent provision in New Zealand?
There is now, but then wasn't.
I see.
Are you talking about the obligations on expert witnesses under the Evidence Act?
Yes.
Yes, but those are separate from the general duty of disclosure, aren't they?
Yes, that's right.
Disclosure of helpful material is not limited to experts.
Yes. Yes, what we say, it's a common law, was a common law duty in New Zealand, in the same way as it was in this country when Ward was decided, and of course in Ward said the disclosure was just one of the aspects of the concept of a fair trial, and that's the point that's made.
So it's a Bill of Rights Act duty?
Yes.
Not just a common law
No,
duty.
that's right. That's right. And of course, as earlier we said, we submit that sections 24D and 25A of the Bill of Rights Act certainly engaged. And one last point before we leave the issue of disclosure and move on to ground 3, if we may, is if this court, as a result of the Teo disclosure, thought that Officer Grantham was in effect covering up that which he knew existed, that is the Teo consultation and the results thereof. If this court thought that he was covering up, then of course he would be covering up to ensure the safety of a conviction. It is not very far away from someone who might mislead or cover up to secure a conviction. And the fact that there was, or appears to be on one reading of it, a covering up, if that had been before the trial court, then of course it would have given some support to one of the defences raised at trial, that is non-deliberate contamination of the tissue.
Right, non-deliberate. Or do you mean deliberate?
Oh, sorry, I did mean deliberate. I meant non-accidental.
Non-accidental, yes.
I beg your pardon. And that, we say, is a matter that ought to be considered under this head. And whether it's considered as a matter of fresh evidence or disclosure, it doesn't matter, we say, but it's something that if this court was minded to accept, then that would have been, of course, material to that defence.
It's a very serious accusation, though, isn't it?
Yes, it is, and that's why I said if that was an inference that this court drew, if it drew, what we have to look at is what the nature of the communication was and how it was described in the affidavit before that disclosure was made. And looking at it, it's misleading. Now, what anyone makes of that, we're not saying, we're not making an accusation, but at trial, if the fact of that communication was before the jury, and if the affidavit of D.S. Grantham was also before the jury, it would be open to them to infer in support of the defence case of deliberate contamination. So we don't make the allegation. What we're saying is that it would be open to a jury if that information was before them.
But how could it have been? It all comes into existence post conviction.
Yes, I agree, but the fact is the point can be made, of course, of all fresh evidence, because that's what it is. If that is a possible inference, it's fresh evidence of a frame of mind.
But are you suggesting that defence counsel would be making this proposition to the jury in his closing speech? Because that would raise a question, I would have thought, in the trial judge's mind as to whether you should be allowed to do that. You'd have to lay a basis for it, wouldn't you?
Well, of course, that's in essence, during the cross-examination of two officers in this case, Officer Grantham and another named officer, that's exactly what trial counsel was putting.
And certainly the prosecuting counsel in his closing address to the jury suggested that this was really the basis of the defence case that Detective Sergeant Grantham had. But I think you'd be very quick to accept, Mr. Hislop, as my Lord, the Deputy President has said, this is a very serious allegation. All manner of judgments can be made on the importance or significance of particular pieces of evidence, and we're approaching it from the perspective of an ex post facto meticulous examination.
Yes.
And one would need to be very careful indeed before imputing to the Detective Sergeant a motive which was not only wrong, but also highly improper in the context of a very serious trial like this.
Yes. We simply make that as a... we're not making an accusation.
Well, that takes us straight back to vice, Mr. Hislop, doesn't it?
Pardon me?
That takes us straight back to vice and to the jury impact test.
Yes.
You either make the accusation here or you don't, because it's us you've got to convince that there might be something in it.
Well, on the face of it, it appears to be misleading. If it was, it's either misleading or it's an oversight.
Well, what I'm concerned about is the further step that you're asking us to infer, which is deliberate cross-contamination. I mean, I can see the force of the argument that there's non-disclosure, and one can well take it to the point of saying, well, there's a bit of covering up here going on. One might be able to accept that, but it's a big step to go beyond that, to having somebody falsifying evidence, which is what it comes to.
Well, we don't know. We can't make that as a positive assertion, even though trial counsel did. All we can say is that if a jury had as fresh evidence the affidavit and the memorandum, one possible inference is, as we say, and bearing in mind the nature of the defence might want to have prated an aid, because certainly if that was one of the two defences that they were running, they had to praise something in aid of it. And all we're saying is that might add to it. Of course, it's a serious accusation, and that's why we hopefully couch it in the careful terms that we do.
But you can't possibly be suggesting that because in the appeal you say an affidavit filed is misleading. There should be a new trial so that there could be more force to the suggestion put to the police officer that he had contaminated the evidence. I mean, what are you really submitting? What use can we make of this, even if it is misleading?
I agree that one has to go one step further than misleading to make the allegation that was made at trial. All we say is that it might have been one of the building blocks upon which the defence could have mounted.
What might have been one of the building blocks?
If the fact now was known to the fact
The
of,
non-disclosure.
yes, the non-disclosure coupled with the affidavit, taken together, one possible inference is that there has been a deliberate misleading. Now, how much that might help the defence when they're running deliberate contamination, one doesn't know, but it's something that it might have caused the jury concern. When taken with the other evidence in the case that the defence did rely on, and that was that this particular exhibit was kept by this officer in his drawer for some months, kept apart from all the other exhibits in the case, unknown to the exhibits officer in the case. In this jurisdiction, that's highly unusual. So that would, before it would become part of that body of evidence. We can't take that point any further. But that is how we put that.
Could I just ask one aspect of this? At the time when the disclosure requirements were incumbent on the police officer,
Yes.
One might have thought that the critical issue would have appeared to be, is this brain or is it not? Mr. Teo's or Dr. Teo's statement is relevant to a different issue. How degenerate was
Yes.
the tissue material? And you're now saying, well, that's an important question because it tells us something about the circumstances under which it was deposited on the shirt.
Yes.
I'm wondering if that's something that would have been apparent at the time when the disclosure requirement was live.
Yep. Yeah. First, there are a number of points. First, if we can go back to the memorandum itself, and it is at Appellant's Supplementary Bundle, and it's 18.
Yeah.
And it is at page 321. D.S. Grantham well knew what the possible implications were when he said, what this experience has done is give me an early insight to possible defences for any subsequent trial. The issue of degeneration or not was in fact important to the issue of identity of brain tissue, as well as the subsequent issue that arose as to how it was deposited. In any event, the short answer is, of course, that the obligation of disclosure on the Crown is a continuing one. and as a continuing one, if the issues in the trial change, then of course it's incumbent upon the Crown to review their disclosure, and obviously that didn't happen. But as I say, the significance was never lost on the officer, and and it was germane not to identity as well as manner of deposit. My Lords, that is our ground 2, and might I please move to ground 3. And this relates to the defence failing to challenge the time of death evidence led by the Crown. My Lords, if I could take the court please to volume 4, and that's page 1799. And it's at tab 9. And it is the summing up of the learned trial judge, and it's to paragraph 10 of the summing up at 1805. The learned judge refers to the time of death evidence as the second substantial piece of circumstantial evidence. I now turn to second substantial piece of circumstantial evidence, and that is the trips to and from Palmerston North and Petone. And he goes on to set out what was, in essence, the rather small window for this or these murders. The distance, my Lords, between Petone and Palmerston North was 93 miles, and it was clear from the learned judge's summing up that the window was indeed probably between 5:30 p.m. and 8:28. So the evidence was the appellant was in Wellington at 5:30 p.m. And then back in Wellington at 8:28 p.m. And at paragraph 14 of the summing up, the last 3 pages, having referred to the time of death at 7 p.m. On the evidence of Doctors Pang, White and Professor Barbazat. The learned judge, bottom of paragraph 14, plainly for the prosecution to succeed, the time of death of around 7 p.m. is essential. If you're not satisfied on the evidence of this or left in a reasonable doubt about it, then it is fatal to the prosecution case. Time of death is dealt with at paragraphs 38 to 68 of our original skeleton argument, and we find that at the second supplement, please, at tab 15.
Do you mean tab 15 in the second supplement, or tab 5? I think it's tab 5.
It is...
it's tab 5.
Yeah, tab 5.
Yes.
Tab 5, that's
I'm sorry, of the what?
Second
supplement.
Second supplement, oh yes. Thank you.
Second supplement,
Yes, there's
supplementary bundle.
Yes. Thank
we set out in detail our case in relation to time of death and the evidence in respect of it. If we can move to paragraph 40, please, of that document. The prosecution witness called on this was Dr. Pang. His trial evidence, and I won't take the court to it, but if for the court's record, his trial evidence is volume 2, and in relation to time of death, he commences at page 934, lines 4 to 14. In essence, in the determination of time of death, Dr. Pang relied solely on the state of the stomach contents and the absence of smell of gastric juices. And the citation for that is page 934, line 24, and pages 935, lines 115. And then again, page 935, lines 27 to 30. However, it is important, if I perhaps take the court to page 936, please, of volume 2.
Sorry, I was looking at something else. The page we're looking at is...
my apologies, it's 936, it's volume 2.
Yes. 936.
And it's line 25 of 936. The doctor is being cross-examined on his time of death reckoning, which he had put at an hour, and then he's asked about it, and he's asked about factors that might alter the timing, and he answers, so death would have to have been soon after that. Yes, to the extent of the psychological, emotional stress or physical stress would affect gastric emptying or digestion. It would be only a matter of minutes to alter the timing, at most a few minutes. Most a few minutes, that's right. The point is that he was asked about the limitations of determination of the time of death by stomach contents. And here he's saying that the only factors that might affect time of death in this case will be limited at most just to a few moments.
No, I think he's saying that she'd have died within a few moments of
Yes,
the injuries.
That's right,
Yes.
and therefore issues of stress and those matters would not
Yes.
bar a few minutes affect the emptying of the stomach. This and like passages we respectfully submit, those that we have just referred to but not taken the court to, demonstrate that Dr. Pang was being, in fact, terribly precise about the time of death. He, in his evidence, said it was an hour effectively after eating, and he says that at 942 lines 24 to 30. I would estimate it to be 1 hour. And then at 943 line 5 to 10.
Sorry, just give me that reference again, please.
Yes,
The first one.
that is 943 line 5 to 10.
Thank you.
Well, he says bottom line 4.2, it's stomach contents and nothing else, having been through the other possibilities.
Yes, that's
and
right.
then that it's about an hour.
Yes, yes. So he's relying totally on stomach contents and the issue of smell of gastric juices, and he estimates an hour, and the learned judge says, so another way of putting it is that it takes about an hour for the digestive gastric juices to flow. It would take less than an hour, so 1 hour is the time bracket, within an hour.
So it's not more than an hour. It could be any time within the hour, could it?
Yes, that's what he's saying. And he wouldn't go in cross-examination beyond an hour and 10 minutes. At 9:50 at line 5 to 15, Dr. Pang accepts a possible margin of error, stretching time of death to 1 hour 10 minutes, but refuses to go beyond that to 1 hour 15 minutes.
So he refuses, you say, to extend it.
Yes, and we say that's important when later we consider the merit of the respondent's argument that Dr. Pang, in fact, was not being precise in his estimate of the time of death. At 955, at lines 4 to 7.
Actually, he said he would go to 1:15, wouldn't he?
No, he didn't. He's
Line 20?
sorry, on
950.
950.
I mean, you're quite right. He's around an hour, and that's all you need.
Yes.
We can stretch it to 1 hour and 15 minutes. It's within my expertise to say that.
Then it goes on, all I'm asking you, doctor, is that if you say it could be stretched beyond an hour and 15 minutes, but that would be outside your expertise, then you're saying it could be stretched, you just don't know beyond 1 hour 15. My opinion is that 1 hour is the time.
Okay.
So he wasn't going to be stretched, is the point.
Well, at the top of the next page, isn't he saying 3 hours is the very maximum?
Yeah. I think 3 hours is the very maximum, and to have a full stomach up to 2 hours is impossible.
That's 3 hours for emptying of the stomach, I think.
Yes, that's what he's saying, yes, for complete emptying. And then he says, Dr. Pang, I put it to you that the literature shows that a heavy meal takes 5 to 6 hours. That's right, isn't it? That is to completely empty from the stomach. It takes 5 hours to empty. And then he says it's possible, yes. But the important thing is he is fixing the time at 1 hour 10, 1 hour 15. He's being absolutely precise before the jury.
But he does, doesn't he, accept it's not an exact science, subject to debate, discussed and so on.
But in the context of refusing to budge beyond 1 hour 15, that rather circumscribes his comment about the exactness of the science, as it were.
Yes. Well, now we're just about on 4 o'clock. Is that a convenient point to stop?
It is. We can stop there.
Again, I ask you how we're getting on without expressing a view that it'll be too long.
No, round 3 will take a little bit more time. We're going slowly, but we will try and speed up.
Perhaps you'd have a word with Mr. Manda and just give him some idea of how long you think it would be tomorrow, so that he has an idea of when he's likely to get to his feet. That would help him in his own planning. Thank you very much. Well, we look forward to seeing you both at 10:30 tomorrow morning.